My name's Miriam Bear. I'm a professor here at Brooklyn Law School, and we are very happy to have with us Jonathan Adler from Case Western and Tamara Piety from Tulsa. We're going to start with Jonathan. He's going to speak for a bit, and then Tamara will speak for a bit. Hopefully, maybe the two of them can have a little conversation with each other if there's any time, and then we'll let you all go so you can get your lunch, and we thank you for being here right now. Okay, with that being said, let's start.
Great, thank you. It's definitely a pleasure to be here today to talk about these issues. It's fun to be back in New York, and I appreciate Joel's invitation. What I want to do relatively briefly is to say a little bit about where we are with commercial speech, and then talk about some threats to commercial speech that I don't think get enough attention or enough consideration. Obviously, everything I say about this is somewhat contingent because what happens in terms of filling Justice Scalia's vacancy will certainly have an influence on what happens with commercial speech doctrine, just as it will have an effect on much of what we're talking about today. The title of the conference, Free Speech Under Fire, evokes the idea that there are threats to free speech, but I think most of us would say, looking at the record of the Roberts Court on commercial speech and even the record of the late Rehnquist Court, is that commercial speech has generally fared fairly well. The Supreme Court has been fairly protective of commercial speech. If anything, has heightened protection of commercial speech, even if it hasn't quite said so explicitly. That the court has continued to recognize that consumers and citizens, or that individuals as both consumers and as citizens, have an interest in the free flow of the sorts of information that accompany commercial messages, and has maintained Central Hudson at the very least as a floor of the protection that is offered to commercial speech. I think that, as many commentators have noted, looking at what the court has actually done in specific cases, it's fair to suspect that at times the court is applying more than Central Hudson in terms of the protection it's offering. At times we have seen opinions in which a majority of the justices have indicated they would like to protect commercial speech more than Central Hudson does, but they have not actually made that their precise holding. We can certainly debate about whether or not the rationales the court has offered in some of these opinions are particularly coherent or consistent. I think there's lots to discuss there, but as a general matter, the results have been quite protective of commercial speech. For myself, I think that one thing that the court has not done enough to discuss or to flesh out in these opinions is to acknowledge the extent to which that commercial speech and the sorts of information and messages that accompany commercial communications permeate our broader discourse and have a very important effect on the way individuals see themselves as citizens, as members of our society, and contain an incredible amount of normative and political content. Just to give one example, after the Obergefell decision, if you went onto Facebook or if you went on social media, you would have seen countless major corporations that had altered their logos to incorporate the rainbow flag in one way or another. These were commercial messages, but they were also political messages. These were efforts to align corporate identities with the political and normative identities of individuals. And we see this all the time coming at it from the other direction. Individuals today, and we can debate whether or not this is a new phenomenon or one that we're just more conscious of, make commercial and economic decisions on grounds that are often not commercial or economic. The individual who drives a Prius, walking in their Toms, carrying their hemp bag with their fair trade coffee while they go shopping at Whole Foods is not merely acting as an economic actor when they are acting as a consumer. They are making normative and political choices. They are both using their purchasing decisions to engage in political action, but they are also engaged in communicative content. These aren't actions that are merely political in the sense of how they devote their dollars. They are communicating to other consumers, to other individuals. They are creating bonds of affinity with others through what we might want to characterize as economic actions, and producers respond to that and are in many respects engaged in dialogue with consumers over these sorts of choices. I couldn't help but notice in the government's response to Apple this past week. One of the things the Justice Department criticizes Apple for is, in effect, trying to use this conflict over whether or not the All Writs Act applies to getting into an iPhone in ways that I don't quite understand, but that using this as a way of defining Apple and its brand, not merely in terms of the quality of the product, but in terms of the political identity that Apple seeks to project and to align with consumers. As noted before, a lot of times the speech we're concerned about is the speech that the government doesn't like, and insofar as Apple's legal position is also a political statement, that is something that the Department of Justice apparently doesn't like. The point here is simply that what we often think about as commercial speech and commercial discourse, as well as what we often characterize as commercial or economic actions by consumers, are both suffused with normative and political content. And that makes it very difficult to talk about regulating commercial speech as speech without creating risks to that dialogue and that discourse that occurs. Now, in terms of threats to commercial speech, I want to mention two that I think are worth more discussion than they often sometimes get. First is the use of restrictions on commercial speech as a way of way for powerful interests, typically powerful corporate interests, to maintain their privilege and positions of power and to suppress competition. And I think it's particularly important and typically overlooked because we often talk about commercial speech as a way for powerful corporate interests to advance their interests. What we tend to ignore is that powerful corporate interests use restrictions on commercial speech to advance their interests. And I'll give a couple examples in a second. And the other threat that I want to talk about is the threat posed by government regulations that compel commercial speech. I think this is an area where the court hasn't quite really articulated a solid understanding of what's involved with compelled commercial speech, nor do I think that much of the academic commentary has. In fact, I think much of the academic commentary makes arguments based on clearly falsifiable premises about the nature of information and communication, particularly what goes on with the listener. Now, in terms of that, the first threat, the threat of powerful interests using restrictions on corporate commercial speech to maintain positions of power to suppress competition, I just wanted to give two examples. Some of you may be familiar with the fact that some dairy producers use RBST, recombinant bovine somatotropin, a genetically engineered hormone to increase the milk production of dairy cows. Some dairy producers don't and believe that there are moral or perhaps even health-related reasons for doing so. The scientific evidence we have suggests that insofar as there are health concerns with using RBST, they primarily relate to the health of the cow, not to the health of the person. But there are certainly those that don't accept the FDA's assessment of the science. Many producers of milk or milk-related products have wanted to disclose to consumers, to engage in commercial speech, to let consumers know that they've made a choice not to treat their cows in this way. And as we might expect, the makers of RBST, as well as competitors that use RBST, don't like this. But the way they've responded is not to use their economic power in their marketplace, but rather to do what those with economic power often do, which is to go to the government to get regulations that cement their position. So, for example, in Ohio, we had regulations adopted that would prevent dairy producers from simply putting on their milk, this milk comes from cows that were not treated with RBST. A purely factually true statement. One that I would argue is infused with normative content. Because for many people, the choice to not use RBST or to not consume such products is a value-based decision. And these sorts of regulations have been adopted in many places. The FDA, for its part, largely as a result of encouragement from the industry, has suggested that to put such a label on a dairy product without an extensive disclaimer echoing the FDA's position that there is no health difference between or material difference between milk that is or is not treated is further effort to essentially restrain or restrict the ability of those within the industry who have a dissenting position to communicate that position to consumers who may care about it. And incidentally, it also suppresses discussion of whether or not RBST should be used at all, because it's harder for those with the greatest interest in this question to bring that information forth. Fortunately, the Sixth Circuit struck down this regulation, but it is an example of the sort of thing we see quite a bit. The other example that I think is worth noting comes with federal restrictions on, again, factually true statements that can be made about reduced risk tobacco products and alternatives. The FDA, through the tobacco law that was passed with the support, and some would say drafting assistance of Altria, aka Philip Morris, restricts the ability of the producers of smokeless tobacco products or electronic cigarettes from merely disclosing to consumers fairly extensive medical evidence that while these products are not risk-free, so if you don't use them, don't, they present vastly lower risks than traditional tobacco products, cigarettes in particular. And in the case of electronic cigarettes, there's significant evidence that many smokers are more able to quit with electronic cigarettes than with other alternatives. And in other words, if they had this information, it might save their lives. And yet the government restricts these sorts of messages. Why? Largely because the largest tobacco company wants to make it more difficult for their potential competitors from informing consumers, their consumers in particular, of reasons why they might want to try another product. Philip Morris is also, for example, encouraging the FDA to deem electronic cigarettes to be tobacco products to be subject to the full range of regulations that cigarettes are forced to comply with, restrictions that will ensure, at the very least, that the only players in the electronic cigarette market are large players like Philip Morris, and will eliminate or dramatically reduce the presence of much smaller firms, done again by suppressing factually true information for the benefit of large corporate players. And this is the sort of threat to commercial speech that I think we should be particularly concerned about. And in my own view, it is a far greater threat than large commercial actors trying to use their weight in the marketplace. There's a long history of the largest firms in a particular industry recognizing that limiting advertising and speech for the industry as a whole actually cements the market position of the dominant players. Now, very briefly, because I know I'm coming close to the amount of time we said we'd speak for, let me talk a little bit about the threat posed by compelled commercial speech. I said that I think that most commentators make arguments about compelled commercial speech that rests on a demonstrably false premise. And that demonstrably false premise is that more information is better and advances the free flow of information in the marketplace. And the reason I say it's demonstrably false is because we have extensive literature, economic literature, psychological literature, showing that the phenomenon of information overload, the idea that there can be too much information, is very real and very true. There's a limit to how much information an individual can process in a given time or over a given period. The way I try and explain this to people is when you pick up your prescription drug and you open the box and there's this long thing that you unfold, how many people read the whole thing? In every audience, there are one or two. But few people read that, and few people, even fewer people, if they read that, actually digest it, comprehend it, and understand it. The idea that by mandating more disclosure necessarily improves comprehension, knowledge by consumers, or informed decision-making is demonstrably false. In some cases it might, in other cases it won't. But the idea that there shouldn't be significant First Amendment concerns about compelled commercial speech because there are no harms is one that is no more true in the commercial context than it is in the context of political speech or other more value-laden speech. I think the way one should deal with this is to simply say that Zouderer, properly understood, is really a reformulation of the Central Hudson framework, the regulations at issue in Zouderer requiring an attorney to inform a potential client that they could be liable for court costs, even though the attorney was advertising their services as being free or as being purely contingent on a contingency basis, easily satisfies substantial interest prong of Central Hudson. In fact, the vast majority of government-mandated disclosures, certainly at the federal level, when we're talking about securities disclosures, when we're talking about health warnings, when we're talking about nutritional labels, easily satisfy the substantial interest standard in Central Hudson. The sort of thing that doesn't satisfy that sort of test, though, is the sort of mandatory disclosure that is based not on some independent governmental interest in protecting uninformed consumers, but rather based on the government's decision to privilege certain, what I believe are inherently value-based messages over others. So if we use the RBST example again, a mandatory label saying that you must disclose whether or not RBST was used is itself a value-based judgment that that is information that should be more relevant to the consumer than the size of the dairy, the type, how much the workers were paid, where the dairy is located, whether the cows are happy cows, and so on. And that's the sort of thing that Central Hudson, I think, should protect against and could protect in compelled speech. I'm out of time, so I will stop there. Thank you.
The title of this is Where's the Fire? In part because my sense is, at least with respect to commercial speech doctrine, the First Amendment's doing pretty well, and that there is not a lot of threat to the First Amendment. But even in areas that we might think of as traditional First Amendment areas, the First Amendment in general, with some notable exceptions, seems to have been doing pretty well. Flag burning, the right to crush small animals, as long as you make sure that you videotape it when you do so. Picketing private funerals with hateful rhetoric, rejecting labels on violent video games that some parents actually wanted, and protecting lying about military honors that many veterans thought was very troubling. To be sure, there are problems, and there are some problems that the surveillance area comes to mind that I think we are still experiencing some very real threats. But I don't think it's appropriate to treat every instance where a litigant raises the First Amendment as a defense or as a cause of action as if they actually are vindicating the First Amendment. I'm not sure. I think in many cases that we should look at what they are doing as simply instrumental. And I will give you one example, which I'm going to come back to in a minute. One of the major things going on right now in advertising circles was just one of many issues devoted to this, but a whole issue of advertising age was devoted to the war on advertising. So they're very concerned about it, and what they are concerned about is ad blocking. Ad blocking. So it's which ad blocking parasite are you going to go after, the consumer or the tech company? Well, obviously going after the consumer, and as the editorial says, forcing ads on people who have demonstrably indicated that they don't want it is kind of bad optics. So the editorial says, I can't believe I'm saying this, but let's go after the tech companies. So let's bring lawsuits. And in fact, I think a lot of what the First Amendment jurisprudence that we see today is an example of instrumental lawsuits that have turned out to have been very useful in a deregulatory campaign. After Citizens United, I wrote a piece called Citizens United and the Threat to the Regulatory State in 2010. In 2012, my book, Brandishing the First Amendment, went through the ways in which I said, as a predictive matter, it seems to me that where we seem to be going is using the First Amendment generally to raise any time that it seems like there's some regulation that you want to strike down. And it seems like this has been pretty effective. But I think that one of the things that we're seeing is an asymmetry. That is, we see a lot of protection for the First Amendment in some areas, particularly when advanced by for moneyed interests, but maybe not so much when it comes in conflict with another very important interest that seems to be lurking in the background, and that is to say, property. So the Digital Millennium Copyright Act and the increasing, as those who are experts in IP, which I'm not, but who complain about the increasingly small area of fair use is one of the examples. Commercial defamation, it seems like it's easier to libel a vegetable than it is a person. The sort of attacks on the Lanham Act, which are more successful for Palm Wonderful than they are for non-corporate clients. But I think the paradigmatic case is the pro football case, which you may not all be aware of, but this is the Washington football team case. The Washington football team's name, the Redskins, has been registered trademark for many, many years, and it got deregistered, I guess is what you call it. The Trademark and Patent Appeal Board decided that it was disparaging and removed this trademark. And one of the things that the pro football argued, amongst many other arguments, and it's a complex case, but one thing they argued was that the Lanham Act in this provision was actually taking a position on an issue of public concern and putting a thumb on the scale, on this issue. Now, just think about this for a moment. I just want you to let that sink in. What is it that they want? They want the government to give them trademark protection. What is the one of the central features of trademark protection? It's the right to stop other people from speaking, unless they pay you or license you. So one of the defining features of this thing that they say they're using the First Amendment to attack is that they would like to be able to suppress other people's speech, or at least get money for it if others are going to use it. Many, many other things here. Jonathan mentioned disclosures. I think disclosures actually bring up one of the things that is closest to my heart with respect to the things I teach. I teach litigation subjects, evidence, expert evidence, and the expert evidence question and the regulatory problem here is really that for many, many years, certainly well into the 20th century, it was taken for granted that the government could make those decisions about which things it was important for the consumer to know, and that the consumer wouldn't have to test for themselves whether or not something was poison, whether or not something was actually had the ingredients in it that it said it did, that you wouldn't have to learn by trial and error whether or not something was going to be working, but rather you could have some reliance, and perhaps I think the literature suggests excessive reliance on a federal regulatory scheme, which is its own problem, but I won't go into that now. But I want to give you just a little bit of background, as I think I've been talking, assuming everybody knows what the commercial speech doctrine is, and I just want to give you a little background about how I think we got here to this sort of juncture where it seems like we're using equality language or the rhetoric of equality to advance the powerful's interests. So Rod Smola, a First Amendment scholar, wrote a piece with a satirical title, very serious import, but he called it "Free the Fortune 500." And I think that to some extent, all joking aside, that is some of what we are seeing happening right now. But what we have is a First Amendment that is very big, right? And Stanley Fish, who's not a lawyer, but who opines on these things, says that we have no recourse but to view this as a consequentialist kind of protection, right? That we have to interpret that as a way, as an injunction to try to advance the values that we think that it was meant to protect. And there are several values that I think that we have generally agreed that it's meant to protect. These are ones that I think Professor Aziz talked about. I talk about them in my book. They are, I collected them in my book, but, and I am not a First Amendment theorist. I don't have a theory about which of these is best or most important, but autonomy of the consumer, autonomy of the speaker, democratic participation, truth, marketplace of ideas kind of truth, and stability, social stability, political stability. And I suggested that actually protecting strong protection for commercial and corporate speech didn't advance any of those, or didn't advance them in a way that seemed net to advance the concerns that we have. The commercial speech doctrine is a product of the late 20th century. It was announced, at least most conventional views, in Virginia Pharmacy. And what you see in the Virginia Pharmacy is a sort of a statement that of sort of an anti-discrimination principle, that we shouldn't restrict advertising even if it's tasteless and we think it's kind of useless because there's some information there. And it was very much listener-centered. But, you know, of course, this was a more limited protection than speech got otherwise. This was one of the important things about it, was that it was more limited than the speech that was, say, political speech, the soapbox, the conventional ideas. And that limited protection was first based on it having to be truthful, and then the familiar Central Hudson test was part of what the test was that was being advanced, and as we've heard, that Central Hudson test is mostly gone now for reasons that it's not been actually, these two things are in some conflict with each other, but I'll pass over that in the interest of time. That sort of idea that we could regulate commercial speech and commercial activity more closely and with respect to its truth is precisely the thing that is most offensive in the context of traditional speech. That is to say, it is manifestly not the case that we want the government to regulate truth in the political arena, right? That's what we don't want. But commercial speech represented a departure from that principle, and for reasons that I don't want to speculate on, but it seems like a traditional separation between economic regulation and others. Rehnquist, that well-known liberal, was a dissenter in this case, and he was a dissenter in an earlier case, which let me go back to Bellotti, which I think Bellotti was the case that brought us the sort of environment that we have now. And that was a case that involved campaign finance, as we know, and it announced this sort of principle, again, this sort of anti-discrimination principle. So we see this coming up first in the commercial speech, a content sort of kind of anti-discrimination principle, and now the speaker identity as a corporation or as a commercial speaker kind of principle. And Rehnquist didn't think much of this. He actually hadn't thought much of the original Virginia Pharmacy case, thinking that this was, elevating commerce to the political sphere. But I propose in my book and some other articles that this was a sort of a bait and switch, that this principle, once it got announced in Bellotti, began being imported into the commercial speech doctrine where it really didn't have much place being. And we see in Central Hudson itself starts to cite Bellotti, which is not a commercial speech case, but they cite it. So there's this gradual evolution of this argument being made. It's being made in a lot of amicus briefs. It's been made in a lot of law review articles. And we get to see the first sort of expression of it in this case, this idea that regulation on the basis of commercial content is somehow improper. But the first one that really brought it home, I think, was Citizens United, and we see this sort of idea that we are disparaging or discriminating against corporations when we have these kinds of rules. It was magnified in the Sorrell case, which was a explicitly commercial speech case. It was not a corporate speech case. And I just pulled some quotes from the case so you can see this rhetoric again and again of disfavored, sort of like we are discriminating against the speaker or the data miners here. And because it's a complicated facts case, I won't go into all of the facts, but there were some actual legitimate questions about where the speech is in this. This was a data mining case, so why isn't this just action as opposed to speech? But what it did is it seemed to substitute this content-based test in commercial speech for the Central Hudson. It genuflected in the direction of Central Hudson at about page 19, but the central focus was on this content-based scrutiny. Now, I would submit to you that that is incoherent. The commercial speech doctrine is, by definition, a content doctrine. It's commercial. The speech that applies to it is stuff that is commercial. And so, at least at some level, you have to conclude that Sorrell seems to have done away with Central Hudson and any notion of an intermediate scrutiny for commercial regulation. Then we have the problem that fraud is also a particular kind of content, and in United States versus Alvarez, commonly referred to as the stolen valor case, we see a rejection of decades of what now is referred to as dicta, but I think before the case might have been viewed as axiomatic. That was that there was no First Amendment value to false speech. Did the First Amendment protect false speech? Of course it did. New York Times versus Sullivan said the First Amendment requires breathing room and that breathing room would include some false speech. But that's a very different thing than saying the false speech itself has First Amendment value. And now, at least in this case, we'll see how far they're willing to push it. This would seem to be, if history is any basis for looking at the future, that this could be imported into the commercial speech doctrine. And let's see. Then, of course, we see Reed versus Town of Gilbert, which is another strong endorsement of the content-based sort of strict scrutiny application. And this very stirring quote at the end in Sorrell, "Many are those who must endure speech they do not like, but that's a necessary cost of freedom." Well, is it really? Is it really a necessary cost of freedom to require people to listen to ads they don't want to listen to? I mean, or to get their data mined when they explicitly don't want to have their data mined. Is that something that is necessary for freedom? I would suggest that, humbly suggest that perhaps it's not. I think I gave you that quote already. But I think one of the things that is a problem here is that a lot of the things that Jonathan referred to in terms of our consumption practices is that we have been turned into a nation of consumers rather than citizens, and encouraged to believe that we can vindicate our political rights through our consumer choices. But the big problem there, I mean, I would like it if that was true, but the problem is that very often it's not. And we have an environment in which manufacturers can lie about their environmental products or procedures or their labor practices or what have you, and without the ability to discipline them in any means through law or private action, we really don't have a way of verifying that's true. So they have the best of both worlds. They can say that whatever they like without any consequences for it. So, one of the quotes that is, I think applicable here in the First Amendment, democracy is also a value. I mean, I'm not sure that any of us who support the First Amendment, which I definitely do, would necessarily believe that it's lexically prior to every other value. We seem to have an allergy to looking at equality and the role of power as it gets expressed through law and through, indeed, the First Amendment in particular. And I would just refer you to that famous or infamous Anatole France quote about the law in its majestic equality forbids the rich as well as the poor from sleeping under bridges. If we don't confront inequality in that way, if we do not confront the differences between empowering those with more resources, I think that we end up in a situation where I don't really think it's too extreme to say that we have a problem with lacking resources that we can trust, like media, that we can trust to tell us what's going on, that we have a problem where things like vaccines are sort of like, okay, who believes in vaccines? You know, raise your hand. We actually do want expertise about some subjects that we are not able to test for ourselves. And universities are situs for the production of some of that knowledge. When everything is for sale, then nothing is trustworthy, and I believe that's a problem for democracy. Thank you.
I was also wondering if you have questions for each other, and if I can start you off, I will tell you what I was thinking about while both of you were speaking. Marijuana, which may sound odd, right? And the reason I was thinking about marijuana is because marijuana is, for the most part, illegal still in most states, and certainly it's illegal under the federal law, and I come at this as a criminal lawyer. Big companies can't put up lots of advertising to get, for example, my child to consume marijuana. Now, she might be exposed to, if she were to watch Bill Maher, she can learn all about how great it is, and she might hear lots of political discussion or even be exposed to it on social media. But she's not going to come across the sort of, you know, the Altria company trying to get her to use marijuana. And I find that interesting because now that I've listened to you both, I think to myself, the mere fact that speech would then become commercial speech about marijuana would then probably, we'd see a huge sea change in that kind of speech, makes me want to not decriminalize it, even though I normally, if you were to ask me before I sat here today, I might have said, pretty good idea. And so I'm wondering what your responses are to that. And literally, that's just my intuition as I was sitting here listening to both of you today. And it is an irony that we can sometimes criminalize conduct, and by criminalizing conduct, we actually cut off speech. So I'm sort of curious what you think.
Yeah, we can cut off the speech in terms of a large corporation advertising. But as in Ohio, we went through a ballot initiative that would have had it passed, a constitutionalized marijuana cartel. So our state constitution was going to be amended to say only a certain number of companies at a certain set designated locations will be allowed to produce and market marijuana. It failed, and it looks like it failed largely because of the cartel part, not because of the marijuana part. Well, the backers of that ballot initiative, who coincidentally were the people that owned the locations and the licenses that would have been approved by the ballot initiative, created a guy, I think his name was Buddy, and he was kind of like the marijuana version of Joe Camel, and he was a guy in a suit, and he went around to college campuses. So you don't close it off completely. But, you know, having a teenage daughter, I actually would be less afraid of a company that sells a product that is liable for fraud, potentially liable for, say, marketing to those that are not allowed to consume the product. I'm less worried about that than I am, for example, her going to a Wiz Khalifa concert. For those who aren't familiar with Wiz Khalifa is one of many, many commercial artists, some of whom I actually like, that celebrate drug use, often in very irresponsible ways, in ways that a commercial company would not do. So I actually think, paradoxically, when a company has its brand name on the line, when it is an identifiable entity that faces potential legal liability for being irresponsible, it on the margin is less likely to promote the sorts of messages you worry about than, for example, all the skater folks and whatever else. You know, there's the one skater guy. My daughter would tell you who his name is, but there's the one skater celebrity whose logo is a marijuana leaf, and so, you know, like all these boys in my daughter's high school, you know, wear the socks that come up to their knees with the bright neon colored marijuana leaf plants, and, you know, they challenge on to say, oh no, this is, you know, so, you know, this is like the Nike swoosh equivalent for this skating brand. This has nothing to do with marijuana. That's actually where I think you get less responsible messaging, less responsible communication than when it's in a more formalized structure.
Yeah, okay. This is really funny because the very, very first thing I wrote as a student was about civil forfeiture. So my instincts in a lot of things are really libertarian, and my civil forfeiture piece is like Cato loves that one. So not so much my free speech stuff, but I actually am right with you. I mean, my instinct would have been to decriminalize, but I'm very concerned about an environment in which you can promote it that way. That said, that's not the thing. I mean, I think it's so incredibly complicated because it's not clear that it's easy to sue for fraud. It's not clear that, where California got rid of its private attorneys general provision in response to the, Nike case, where the FTC is not bringing a lot of cases, where the barriers to bring a case, you have to get over the puffing doctrine, the things that, reasonable people shouldn't believe. I'm not sure that private enforcement would be enough, and it's worrisome. I am very concerned about the state being in the lottery business and promoting and advertising lotteries, which I think are regressive tax, and I don't know. So it's complicated. Yes, that's.
Do we have time for, any time for a question? All right, do we have questions from the crowd? From anyone out there?
They're all hungry.
They're all
Oh,
hungry.
wait, there's someone, really, we got one over there.
I'm just curious as to where you stand on right publicity issues.
The what?
Right publicity.
Oh, right of publicity. Yeah, no, that was in my list of stuff, and I didn't address it. I think there is somebody, Rebecca Tishnet has a great blog on advertising, and she mentioned a guy, Andrew Gilden, who's, and it seems like from my quick read of his article that it seems like right of publicity also is splitting along these lines of if the plaintiff or the person that's using somebody's image is already powerful, they seem to get that designated as raw materials, but if the person is not so powerful that whose image has been used, then not so much. But one thing I meant to mention, which is not responsive to your question, but those of you who are interested in the Lochner stuff, you should definitely read Amanda Shainer's The New Lochner. I sort of outlined bones. She put the flesh on the bones, definitely, of that argument. So if you want more specific examples, Amanda Shainer.
Should we wrap up?
I know.
Oh, yes, all right. I have been asked to announce that the next panel will start at 2:30, and I think we're going to have to wrap.
There was a guy over there that
Oh, I know. Larry, did you had your hand up?
Yeah,
You wanna-
I was wondering, the slant ban case, what's the impact you think it has on the Redskins?
I think the pro football team is going to win. And I don't know, there's so many of these cases that I don't know if they were stalking horses or just like coincidence, or I don't know, who knows, but I think, one of the real big challenges for me is that I am not a securities law person. I am not an FTC. These are all many, many, many regulatory regimes, intellectual property that are implicated by this that I don't have that deep knowledge about. I'm not an election law person, and yet this is bringing a lot of this stuff together, and so, I wish I knew more of the details, but yeah, I think that case is going to kill it's a boon to pro football.
If I could just say really quickly, it's interesting that a lot of these areas that we're concerned, we're talking about the Lanham Act, we're talking about DMCA, we're talking about the Mickey Mouse Protection Act, of which I've refused to use the real name of. These are statutory enactments at the behest of large corporate power. So I think, to me, that reinforces the point that however much we're concerned about large accumulations of corporate power in the marketplace, we should be more afraid of the ability of large corporate power to enact laws and regulations that cement their position. We may not like the former, but the latter is far worse, in part because it's so hard to do something about, right? So if the Lanham Act was not quite as protective of trademarks, if the Mickey Mouse Protection Act did not do quite so much in terms of extending copyright terms, then the threats that that might pose to open discourse and to the mammals would be less of concern, and the dinosaurs would be more able to go extinct when their time came if it weren't for those statutory structures.
So with that, I'm going to thank our panel.